Everything that is explained in this video is summarized from the CoinMarketCap. And also, please don't forget to support my channel for more XRP updates and some other cryptocurrencies as a whole. Now take a look at this. Judge Torres ruling on XRP secondary market sales challenged by exec official. Both Coinbase and the United States Securities and Exchange Commission SEC experienced major changes as a result of the decisions made by Judge Catherine Filla in the case between the two entities. On the other hand, the verdict constituted a victory for the SEC, albeit a partial one. According to John Reed Stark, a former chief of enforcement for the Securities and Exchange Commission, Judge Filla is in complete disagreement with the decision made by Judge Torres in the Ripple versus SEC case, which stated that secondary sales of XRP cannot be considered investment contracts or unregistered securities. The Securities and Exchange Commission has submitted a request to the court requesting that it issue a final judgment against Ripple, along with penalties and fines totaling roughly $2 billion for violating federal securities law. Judge Torres' decision in the XRP lawsuit is contradicted by the former SEC. John Reed Stark, who had previously served as the chief of the SEC Office of Internet Enforcement, stated that the most significant setback for Coinbase and Ripple was the fact that Judge Filla completely invalidated the reasoning that Judge Torres had presented in the Ripple decision, which stated that secondary sales cannot be considered investment contracts because the buyer is unaware of who they are purchasing from. According to the statement made by Judge Filla, transactions involving crypto assets that take place on the secondary market are not strictly precluded from being considered investment contracts. According to the Howey test, the courts are expected to take into consideration the economic reality of the transaction in order to assess whether or not the transaction in question constitutes an investment contract. According to Judge Filla, contrary to the assertions made by the defendants, the question of whether a specific transaction in a crypto asset constitutes an investment contract does not necessarily depend on whether an investor purchased tokens directly from an issuer or rather in a transaction that took place on the secondary market. On the other hand, in the case of United States Securities and Exchange Commission v. Ripple Labs, Judge Torres made the following decision. An institutional buyer knowingly purchased XRP directly from Ripple pursuant to a contract. However, the economic reality is that a programmatic buyer stood in the same shoes as a secondary market purchaser who did not know to whom or what it was paying its money. When it comes to the application of the Howey test in terms of programmatic sales, John Deaton has expressed his agreement with the formulation of the Torres doctrine. On the other hand, Judge Torres has declined to examine secondary market transactions. Coinbase versus SEC. The decision Coinbase was found to have participated in the unregistered offer and sale of securities through its staking program, according to the decision provided by Judge Filla. As a result of the ruling made by the court, the lawsuit will proceed to the discovery phase and then to the jury trial. Considering that the lawsuit is moving forward, Coinbase will rely on its legal arguments. The Securities and Exchange Commission, SEC, claims that the company works as an unregistered broker, among other allegations. On the other hand, the court rejected the portion of the case that concerned Coinbase's role as an unlicensed brokerage for the wallet service. Although certain tokens satisfied certain elements of an investment contract, the verdict stated that Coinbase did not serve as a brokerage. This was the conclusion reached by the court. In the midst of a lawsuit filed by the SEC, attorney Fred Rispoli investigates Ripple's XR pricing. In Ripple's case, the debate is sparked by allegations that the company made discounted sales to institutions. The SEC is seeking a fine of $2 billion in the continuing struggle, and Ripple's answer is significant. In the middle of the continuing legal dispute with the United States Securities and Exchange Commission seat, attorney Fred Rispoli investigates the mysterious pricing of Ripple's XRP. Controversy has been ignited following allegations of discounted institutional sales, which have raised doubts over the level of openness and fairness that exists within the cryptocurrency market. Amidst a lawsuit from the SEC, attorney Fred Rispoli has provided some insights on the price enigma surrounding Ripple's XRP. Controversy is sparked by allegations of discounted sales at institutional establishments. Will transparency prevail, or will investors in XRP be forced to suffer the brunt of the consequences? The next move that Ripple makes will determine the outcome. The essence of the situation is Ripple's sales approach, in which the business allegedly sold XRP at discounted rates to select institutional purchasers. This is where the controversy resides. Based on risk bully's investigation, it appears that this technique may have played a role in the relatively low price of XRP on the market. On the other hand, the Securities and Exchange Commission, SEC, asserts that such preferential treatment resulted in a price disparity which was detrimental to regular investors who first purchased XRP at higher prices. The severity of the problem is shown by the motion that was submitted by the SEC, which seeks to impose an astronomical fine of $2 billion against Ripple. In its argument, the regulatory agency contends that Ripple's sales approach breached securities regulations and lacked transparency, which resulted in an unfair playing field for investors. Further, Rispoli suggests that discounted sales to institutions could make market volatility worse, particularly during price rises, because these institutions may unload significant volumes of XRP. This is especially true during price rallies. Retail investors who are responsible for providing exit liquidity for institutional players could experience a disadvantage as a result of this. Even though Ripple is in the process of preparing its response to the motion filed by the SEC, the outcome of the legal issue is yet unknown. The resolution is anticipated to have a substantial impact on the future trajectory of XRP's pricing dynamics and regulatory compliance within the cryptocurrency industry. Despite this, the consequences are enormous for both Ripple and its investors. Ripple's next action is the essential to resolving the price riddle and restoring confidence among XRP investors. This is because Ripple is currently facing rising scrutiny and legal concerns. When will the conflict between XRP and the SEC ultimately come to an end? In addition to Wolf of Wall Street, James Murphy, the author, Scott Melker, dives into the complexities of the SEC's damages theory in the Ripple case, underlining what he considers to be a fortuitous turn of events for the cryptocurrency organization. How can we decipher the SEC damage theory? A major issue about a legal precedent that states the Securities and Exchange Commission is required to demonstrate misconduct by identifying victims who have lost actual money is brought up by him as a result of a decision made by the Second Circuit Court of Appeals. Melker throws light on the losses theory proposed by the SEC and draws attention to a significant issue. No users of XRP can be identified as having experienced a loss of money. Instead, the case that the CSE is presenting is predicated on the notion that certain purchasers purchased XRP at reduced prices. This is an allegation that goes beyond the scope of pecuniary harm because it does not demonstrate that certain businesses have suffered financial losses, because the SEC has not been able to identify identifiable victims who have suffered actual financial losses. The case that they have presented is much inferior. The disgorgement concept, which seeks to repay illegal earnings to those who have been damaged, is rendered ineffective when there are no victims that can be independently identified. Because of this, the legality of the interest claim of $200 million that the CC has made is called into doubt, because it is dependent on the presence of customers who have been dissuaded from purchasing and have experienced financial injury.